welcome to our annual update, annual looking back and annual looking forward. My name is Greg Burgess. I'm one of the partners in the employment team at DMH Stallard, and good morning to Will.
Morning, everyone.
Will is another one of the partners in the employment team, and between Will and I, we're going to be running through today's session. I'm going to be looking backwards, and Will is going to be looking forwards. In terms of timings, we would expect to be talking for maybe 50 minutes to an hour initially. If you have questions, then use the Q&A function. And if you have any problems, in terms of technical problems, can you put that in the chat? And then our support team in the background will try and support you with any technical problems. But questions in the Q&A, and then we should have time at the end for Will and I to go through any questions that you raise. Okay, so I'm going to get stuck in. And I am going to look, first of all, at a few cases from last year that I've sort of picked out as ones which I think have general application, particular interest for any particular reason. So let's get stuck in, please, and look at the first case. So, as always, I'll try and give you a bit of a flavour for the facts, the story behind the case, and then I will look at what we can take away from it. In this first case we're looking at, it's a claimant called Mr. Ngole, who was applying for a job with a charity up in Leeds called Touchstone. And they're a charity. They offer outreach supports to people that have come out of Wakefield Hospital and have typically severe mental health disabilities. And Mr. Ngole applied for a job as a mental health support worker, and he went through the interview process and he got a conditional offer of a job. Now, in the course of the onboarding, someone within Touchstone's organization did a Google search of Mr. Ngole, and they found some comments on Facebook which were negative about the LGBTQ+ community, and in relation to same-sex marriage, Mr. Ngole being a practicing Christian, and he had expressed his Christian views on Facebook. So they decided initially to withdraw the offer to Mr. Ngole of the job, but they did say to him, come in for a second interview for another meeting. We've got some concerns and we want to discuss those concerns with you. Their concerns weren't just about the fact that he would be working with vulnerable people, but it was more the fact that within their organisation they had around 35% of their staff were LGBTQ+ themselves, and they were concerned that his views would be viewed negatively by colleagues. So they brought him in for a second interview, for a chat, to try and appease their concerns, and he wasn't able to appease their concerns. So they withdrew the job offer, and he issued a claim in the tribunal claiming discrimination because of his religion and belief. And what the tribunal found, they found actually in favour of the charity, that their refusal to reinstate the job offer was proportionate. He'd been given that second opportunity for the second interview and to sort of appease their concerns, and he wasn't able to do so. So I think in that case, because they did go that extra mile in terms of that second meeting to try and discuss with him those concerns, that was a reason why they were able to defend successfully his discrimination claim. Okay, next case. Okay, so this is a case involving people who are on maternity leave and their redundancy rights. Okay, so under Regulation 10 of some 1999 maternity parental leave regs, as you may know, if an employee is on maternity leave and they are made redundant from their role, they have the right to be offered, not just considered for, to be offered a suitable alternative vacancy. And in fact, that right has actually been extended in the last year or so. And that if they're if they are pregnant, they also have that right to be offered, not just considered for, a suitable alternative vacancy. And what we had in this case, which is something which I must admit I've discussed with colleagues over many years as to how far this right goes, but this case helps us to understand. So the situation is this: is you've got a redundancy exercise where you've got a pool of individuals who are going to be put in a pool and gone through a scoring exercise. In this case, Carnival had team leaders. They were going from 21 to 16. So the pool was of 21 people. Ms. Hunter brought claims for unfair dismissal and maternity discrimination because she was selected for redundancy and she wasn't offered suitable alternative employment. The question was one of the roles, the 16 remaining roles, suitable alternative? Should she not automatically have the right to that role because she's in that role anyway? And the tribunal actually found against her because they concluded that no such vacancy existed by the time of the claimant's redundancy because the vacancy had gone. So where you have a pooling situation and you have people who are either pregnant or on maternity leave, then they can be put in the pool and you can score them along with their other colleagues within the pool. And only once they have then been selected, so they have been, they haven't retained their existing role, do you then have the obligation to offer them any suitable alternative. So stage one is put them in the pool and apply the scoring along with everyone else. If they are selected, stage two is that you then look at alternative employment. And if there is something that's suitable, then they must be offered that suitable alternative role. So some clarity there for a redundancy pooling situation. Next slide, please. Okay, we go into the world of football and football referees, a case which did catch the headlines last year, related to football referees, and in this case, it's actually a tax case. So it was a case brought by HMRC against the Professional Games Match Officials Limited. So this is the company that engages referees. In this case, it was in the Championship matches, so not the Premier League, in the Championship. And in the Championship, the referees are part-time. They get a match fee, they get expenses, and they actually get performance-related bonuses. And the question, in this case, was a tax question, but it's relevant to, more broadly to employment law as well, because the question is, were they employed or were they self-employed? So it went to the Supreme Court, so it went to the highest court we have. And what did the Supreme Court find? Well, they said there's a three-part approach with concepts which will be familiar to us as we're talking about mutuality of obligation and control for many years. So in this case, in terms of mutuality of obligation, once the referee arrives at the ground, he is contractually they're contractually bound to referee the game, and in return for that, he will get a payment. Okay, so there was enough mutuality of obligation in relation to these football referees. In relation to control, the Supreme Court found that there was sufficient control, looking at the contractual terms between the individual and the Professional Game Match Officials Limited. There was sufficient control, and therefore it was found that the referees were employed for tax purposes. And the final part of the approach is consider all the relevant circumstances, which obviously is a bit of a catch-all. But in this case, it was found that the referees, for the purposes of PAYE, they were employed by PGMOL. Okay, well, again, another employment status case. We've seen all sorts of different employment status cases over recent years. And of course, the Uber Aslam cases, so the taxi drivers, the gig economy workers have been very much in headlines for a number of years now. This was a case involving a volunteer. And the question for the court in this case was whether Mr. Groom, who was a coastal rescue officer who had been working for the MCA, the Maritime Coast Guard Agency, for 35 years, in fact, since 1985, whether he was a worker. Okay, so he'd been working for this significant period of time. His relationship, let's call it that, with MCA was terminated with immediate effect following a disciplinary matter in 2020. And as I say, the question for the court in this case was whether or not he was a pure volunteer, whether he was a worker, or whether he was an employee. His actual claim that went to the EAT was around the right to be accompanied. So a worker has the right to be accompanied to a disciplinary hearing. Okay, he was saying he was a worker and therefore he should have that right. And what the EAT said is that when Mr. Groom attended an activity which gave him the right to remuneration, so he would get a call out, presumably like a lifeboat man, he would get a call out, he would actually have the right under his contract with MCA to be paid. And he would get paid for his call outs. And the EAT said that once he was called out, he then had a contract which came into effect. And the fact that the contract described him as a volunteer did not actually prevent him from being a worker. He was a worker, and therefore he had the right to be accompanied. So just remember, we're not talking though about an employee. So he wasn't deemed to be an employee, so he couldn't bring an unfair dismissal claim under the Employment Rights Act. They can only be brought by employees. But he was found to be a worker. So in that case, the contract was key, but also the fact that he had the right to remuneration. He said, well, there's other coastal rescue officers who don't actually get the payment. They don't ask for the money. Some do, some don't. So whilst there's a right to remuneration, people don't necessarily get paid. The court said that's not relevant. He had been paid. He did have a contract, and he was a worker for the purposes of the right to be accompanied. Okay, equal pay. Well, this has been in the news for, well, it has been for many years. It's one of those issues that's been in the background, but has been building momentum. And some say that this line of cases, these cases that are being brought against typically the big supermarkets, are the start of a wave of claims by private sector, against private sector companies. So they're very much, you're right to have these on your radar because the numbers are pretty terrifying, firstly. But secondly, I do expect over the coming years to see more equal pay claims brought against organisations of all shapes and sizes. Let's just see where we are in terms of these claims. They take a long time because they are very complex by their nature. But let's deal with Next first, then we'll look at ASDA, and then we'll try and draw out some guiding principles. So in relation to Next, they've had around 3,500 claims by female sales consultants who work in their stores. And the claims that have been brought by them are that they are doing work of equal value to their male colleagues working in the warehouse. And the tribunal found in favour of the sales consultants. Where there's claims for work of equal value, they involve a very forensic exercise by the tribunal by looking at chosen comparators, comparing the work of the claimants against the comparators, looking at things like job evaluation studies and some pretty detailed expert evidence. But in this case, the tribunal concluded that the work being done by the ladies in store was of equal value to the men in the warehouse. And what Next said often is the case in these cases by the employer, they say that, well, the market rates for people working in the store were lower than the people working in the warehouse, so we had to pay people in the warehouse more. It just so happens that proportionally there are more men working in the warehouse and there's more women working in stores. But that argument was not successful for Next in that case, and it's expected to cost Next around £30 million, so a significant sum of money. Now let's look at Asda. The numbers are even bigger for Asda, and we had a judgment from the tribunal which was published last week in the headline case, the lead case. The claimant is called Brearley, Brierley, but there's around 55,000 female store workers for Asda who, similar to Next, they claim they're doing work of equal value to their male colleagues working in the distribution centres. Okay, now the tribunal judgment, which I'm not going to say I'm going to encourage you to read because it's actually 350 pages, and it looks at the 14 lead claimants. So what happens is you've got 55,000 claimants. The tribunal pick what they think are 14 lead claimants, so typical cases, and then they had to look at the comparators that had been identified by the claimants, the people that worked in the distribution centres. And then the job of the tribunal was to go through every single role of the lead claimants and then compare it against their chosen comparators, and then listen to the expert evidence, and then decide whether the work being done by the lead claimants was of equal value to their male colleagues. And in this case, as you'll see from the second bullet point, 12 out of 14 of the lead claimants successfully established that their work was of equal value to their male comparators. Headline from the union is Asda's facing a potential £2 billion claim. It's around £20,000 I've read elsewhere per claimant of potential liability. Only 12 out of the 14 were successful, which leads, I think it was about 21% of the claimants as a total will be unsuccessful. But again, the numbers are huge. We wait to see whether it will be appealed. It's only at employment tribunal level now. It's taken just close to 10 years to get to even this point. Asda's tactic throughout seems to have been one of delaying things, putting up every obstacle they can. So one would expect that there will be an appeal to the EAT, and this will go on and on and on. But as we stand as at now, the individuals have been successful. Where does that leave us? Well, there's other claims that are in process against Sainsbury's, against Morrison's, Tesco's, and the Co-op, all very similar in terms of comparing a cohort of female workers against a cohort of male workers in a different part of the business. Have we seen more equal pay claims in what we do? Well, I've seen a few more added on to tribunal claims. I certainly haven't seen many or any group claims yet against sort of our client base. But the direction of travel, I think, is that there will be more. I do think there will be more. And if you do get one, they are very complicated and protracted in terms of the defence of those claims. So they can be a real headache for employers, and they can require a lot of work. So you need to be mindful of that. What can you do to address things now? Well, it depends on your pay structure. It depends on whether you have pay ratings, whether you have job evaluation. If you do job evaluation, make sure that you're regularly reviewing that and updating that. So the job evaluation studies that you do are recent, and therefore that would be more persuasive to the tribunal when you get to try and argue the material factor defence, such as the market rate. That's where Asda's probably going next with their defence. They've got a final stage in the tribunal where they will argue that market rates dictated the difference in terms. So this litigation will go on and on. You'll see headlines for Tesco's next, maybe for Morrison's, etc. In terms of your day-to-day, we do expect to see more and more equal pay claims coming through over the coming years. All right, so we're going to change direction. We're going to look at a claim involving flight crew, cabin crew for Virgin Atlantic off the back of COVID. So at the start of COVID, of course, the aviation industry was severely affected. Virgin Atlantic went through a redundancy exercise and they chose certain selection criteria. And these 12 flight crew questioned the fairness and the lack of transparency of the selection criteria. And in the course of the tribunal proceedings, Virgin Atlantic disclosed 50 pages of internal documents, which they redacted. So there was information in there about employee costs, about potential savings. And they said that that information was commercially sensitive and not directly relevant or necessary for the purposes of the tribunal proceedings. And the question in this case was whether or not redacted internal management documents should be disclosed, first question. Second question, or should unredacted versions of the same documents be disclosed? And what the 12 claimants did is they went to the tribunal and made a request application for specific disclosure. So they go to the tribunal and say, okay, we've been given 50 pages of internal management documents. They've been redacted. We want the unredacted versions. The tribunal ordered specific disclosure, and that was appealed by Virgin to the EAT. And the EAT agreed with the tribunal. They said that you need to provide the unredacted documents because it was likely to be relevant when considering the fairness of selection criteria. And it was also likely to be relevant when considering Virgin's argument, their defense, if you like. They would be saying, well, the selection criteria were a proportionate means of achieving legitimate aims. So part of the defense to discrimination claims. So that was therefore directly relevant. All of the contents of the 50 pages must be disclosed, and therefore they were disclosed, unredacted. What do we learn from this? Well, we spend a lot of time, Will, myself, and the rest of the team, reminding clients that internal emails, internal management documents do need to be drafted carefully and considered carefully, because far more is disclosable than employers often realize in tribunal proceedings. And secondly, disclosure of internal emails, confidential documents can often be actually quite fatal to successfully defending tribunal claims. So we always remind our HR contacts to tell the business to be very careful about what you're saying on emails and in internal management documents. Okay, we're now going to look at a couple of cases involving reasonable adjustments. First case, Mr. Glasson. He worked for the Insolvency Service and had done for some years, and he went for a new role. Mr. Glasson has a stammer, and prior to going for interview for the new role, he asked the employer for more time in the interview to answer questions because of his stammer. And they were aware of his stammer, and they accommodated his request, and they gave him more time for his interview. The outcome of the interview was that he just missed out on the job, scoring 1 point lower than the successful candidate. So he brought claims under the Equality Act. he brought claims under Section 15 and Section 20. So Section 15 is the claims where disabled employees can say, I've suffered less favourable treatment for something arising from my disability. Okay. Section 20 claims are the reasonable adjustment claims. But what we see in most claims issue is the claimant will issue claims under both sections. And it's then for the employer to defend both those sets of claims. Now, in this case, what Mr. Glass had done, as I say, he had told them he needed more time. What he said in the tribunal when he brought his claims is that he suffered in this interview because he had gone into restrictive mode, as he calls it. So he would only give short answers to some questions to avoid him stammering. But what the tribunal said is, well, your employer wasn't aware of this being an impact of your disability, this fact of going into restrictive mode. They didn't have actual or constructive knowledge of your disadvantage, this restrictive mode, and so his claims failed. So they were aware of his need to have more time to answer questions, and they made an adjustment for that. But they weren't required to make a further adjustment, accommodation, if you like, for the fact that his answers might have been shorter, which might have meant that his scores were lower, which might have meant that he was unsuccessful, partly for that reason connected with going to restrictive mode. If he had said to them, it's possible that my answers will be short, and therefore don't mark me down effectively for that, then he might have been in a much better position. But in this case, the reasonable adjustment they had implemented, giving him more time to answer questions, was good. They weren't obliged to make that further adjustment because they weren't aware or didn't have constructive knowledge of the restrictive mode issue. Okay, and then just compare that case with another trial period case, which is this case involving Mr. Mello, who was a pest control technician from 2016 at Rentokil. Shortly after, I think about 9 months after he was appointed, he was diagnosed with MS, and Rentokil made a number of adjustments to his role. 2019, so about 18 months, 2 years later, he applied for a different role, a service administrator role, so he wasn't out in the field. He attended an interview and he did written tests, but he was unsuccessful, and he was therefore dismissed for capability. He couldn't do his substantive role, his main role. They looked to redeploy, and they felt that he wasn't going to be able to do the service administrator role. So the question in this case was whether or not he should have been, they should have done more for him in relation to the service administrator role. What the tribunal found, I'm sure much to Rentokil's frustration, was that it would have been a reasonable adjustment to give him a trial in that service administrator role. Even though they had gone through their interview and assessment process and concluded, well, he wouldn't be able to do it, they should have gone further, given him a trial, and see how he got on. I don't know much about what the role is. Judging by its title, I'm guessing it's a relatively junior role. And I'm guessing the tribunal might have thought, well, give him a go. It's a relatively junior role. He may be able to prove actually he can do it, in which case it would have been a reasonable adjustment to give him that trial. So I don't think we can say it's always the case that you must give a disabled employee a trial in any alternative role. I don't think we go that far, but certainly it's something that should be considered. And if you're being cautious, then go ahead and do offer that trial. Okay, who saw the news yesterday? So I changed the heading in the top of the slide to 1 for 2025. So in the news yesterday was the case involving a Mrs. Higgs. This is a case that's been running for some years. So she worked at Farmers School, and she had various roles, but most recently she was a pastoral administrator. She's a Christian, and she was expressing her views, her Christian views, on Facebook. And in 2018, a parent anonymously complained to the head teacher about Facebook posts that they had seen that Mrs. Higgs had made. And there were 2 posts of concern to the school. And what she was asserting effectively in her post, because she was asserting her Christian beliefs, was that gender is binary and not fluid, and that same-sex marriage cannot be equated with marriage between a man and a woman. So she had made these 2 posts expressing her Christian views. She was dismissed for gross misconduct because of the posts, and that dismissal was in January 2019. She brought claims for direct discrimination on the grounds of religion and belief. She said, well, I was just expressing my Christian views, and I was perfectly entitled to do so. The Facebook posts were private, in as much as they were only made to her, I think, 200 or so Facebook friends. There was no connection between her Facebook account and the school, so didn't say that she worked at farmer's school or anything like that. They were private expressions of views to her cohort of Facebook friends. So the question was whether or not that was discrimination. So moving to the next slide. The Court of Appeal issued its judgment yesterday, and they found in her favour. So the first part of the judgment was that she had been dismissed because she expressed a view based on her Christian beliefs. So she had suffered less favourable treatment, dismissal, because of her religious beliefs. So she got over the first hurdle in terms of a direct discrimination complaint. What the employer must then show is that the dismissal was a proportionate response to the situation. And what the Court of Appeal said was that neither the language of the posts nor the risk of reputational damage to the school were capable of justifying her dismissal in this case. She hadn't expressed any views at work. She hadn't said anything inappropriate about her attitudes to pupils. She had made these comments in amongst her Facebook friends, and there had been no connection between those comments and the school. The schools talked about the potential for reputational damage, but the court said, well, that wasn't made out. There was no connection between her Facebook profile. In fact, her Facebook profile was in her maiden name, not in the name she used at school. And therefore, the school was unsuccessful in their justification defence. So she was stood outside the Royal Court of Justice yesterday, and you may have seen that on the news yesterday as well. Okay, so I'm just going to touch on some legislative updates from the last 12 months before Will then looks ahead to what we've got coming through with the Labour government. Okay, next slide, please. So new rules from last January around annual leave and holiday pay, an area which has caused a lot of headaches and still does for employers in relation to how they calculate annual leave and holiday pay for their staff. Where we are as at now is as follows. If you have people, workers who work irregular hours, so not 40 hours a week working Monday to Friday between 9 and 5:30 or whatever it is, if they work irregular hours from week to week, from period to period, you are now allowed to roll up their holiday pay at the 12.07% pay rate for leave years that start from the 1st of April. You have to apply all earnings in the relevant pay period, and you need to identify rolled up holiday pay on the payslip. Okay, so in the relevant pay period, so let's say you pay people monthly, you look at everything they've earned in that month, whether that's base pay, whether that's a shift allowance or whatever. You then apply just a 12.07% and on the bottom of the payslip you will have holiday pay, which will be 12.707% of whatever the earnings are in that month's payslip. So for irregular hours workers, we can now use the 12.07% approach. For regular hours workers, it's slightly complicated still, but for what we call Regulation 13 leave, so the minimum right under the working time regulations, which is to 20 days holiday, that should be based on normal remuneration over a 52-week reference period and average pay received. So you should be putting in commission, one-off discretionary bonuses, overtime. That has been the law for a few years now as a result of various cases. Came through about 3-4 years ago. I am still seeing a lot of employers are taking the risk, which is fine, allowed to take the risk for sure, and not actually adjusting their holiday pay calculations and to reflect normal remuneration. A lot of it is still done on basic pay. That's just a risk that you have to be aware of and inform your employers of. But it is still an area which causes headaches for employers. Okay, flexible working is now a day one right as of the 6th of April last year. What's changed? They can now request 2 flexible working requests in a 12-month period. The employee no longer has to explain the impact on the business and how any such impact might be dealt with. Although in practice, that's part of the discussion, I think. What impact will it have on the business? And then the business needs to be discussing and considering its concerns about that impact. And they must consult the employee. Well, most, if not all employers, if they're dealing with a flexible working request, will consult the employee. Although what you've got to be careful of is situations where you have a discussion or a consultation with the employee about their request, but you go into it basically putting up the shutters and saying it's just not going to work, this is why, and there's no real two-way discussion. We always would say to employers, if in doubt, try it out, do trial it, but that's not always commercially palatable for employers, and so risks have to be taken. In terms of delivering an outcome, you've got 2 months to deliver the outcome. It was formerly 3 months, so that's another change. Okay, and then just in terms of the new law that came in October, again, there's quite a lot in the news about it. I'm not sure it's going to make a drastic difference in practice, because hopefully most, if not all of you, were pretty hot in terms of making sure that you have in place harassment, bullying policies. But the new law said that there was a new definition of sexual harassment. So we have the definition, which is the unwanted conduct of a sexual nature, which has the purpose or effect of violating dignity, creating that environment of hostility, degradation, etc. Where we see most cases always with harassment is around the effect of the harassment, not the purpose. It's very rare for a harasser to have the intent to harass someone. Those are quite extreme cases. What we see is a lot of cases around the impact someone's conduct had on someone of the opposite sex. And that can be enough to make out harassment. It doesn't have to be the opposite sex. It can be a man harassing another man, and so on. What's the new obligation? It is an obligation, a positive duty to take reasonable steps by the employer to prevent sexual harassment. Okay, and if you don't, there can be a 25% uplift in compensation, and the EHRC can take action themselves. What are reasonable steps? Next slide, please. So, risk assessment. Policies, are they fit for purpose? You probably all have anti-harassment policies. You might have done some staff training, you might have done some manager training, but these things are absolutely a minimum now, but it starts with that risk assessment. So do your risk assessment to identify areas of vulnerability and risk. What are you doing to address those? Take steps to address those areas of risk, and then make sure your training and your policies are up to date and in place. What steps are there to encourage people to report inappropriate behaviour, and what protections are in place for those who make complaints. So make sure that your framework for dealing with harassment covers all those things, but it very much starts with that risk assessment, which hopefully you've already done, and it is very much in progress in your businesses. I'm done. Okay, so I'm going to pass over to Will. As I say, if you have any questions, put them in the Q&A. I'll keep looking, and at the end we'll deal with any questions that come up. But Will, over to you.
Many thanks, Greg. So yes, as Greg said, I'm going to be looking ahead, and in particular at legislation that the Labour government either has already brought in or is planning to bring in over the next year or so. The vast bulk of it's going to be the Employment Rights Bill. That's the headline one that got introduced very rapidly after Labour came to power. There's a couple of other little bits and pieces I'm going to highlight to you as well. So starting off with the one that probably hit the most headlines in terms of the Employment Rights Bill is unfair dismissal and the proposal that's going to become a day one right. So obviously at the moment, in vast majority of cases, employees need 2 years of continuous service to have the right to bring unfair dismissal claims. Rare exceptions such as whistleblowing claims, discrimination claims, those sorts of things. But for vast majority, 2 years is the threshold. So the idea is that it will become a day one right. So every employee from the start of employment would have at least some unfair dismissal rights. It's not going to come in just yet. We haven't got an exact implementation date at the moment, but it's expected to come in probably around about autumn 2026. But again, it's something to start getting our heads around now, so we're ready to go. And the way that it works is that it's not going to be an absolute straightforward, every single employee on their very first day has got full unfair dismissal rights. It's been recognised that employers should at least be allowed the benefit of basically a probationary period to assess an employee's suitability when they very first start. So that has been included in the draft legislation, and it's what's called this initial period of employment. And basically, what will happen is that if an employee is in that initial period, so the probationary period, then there will still be a requirement to follow some process. Again, we haven't got the detail yet about what that is, but I expect it to be something basic along the lines of there must be a meeting to discuss the issue, and a very low level, versus someone with longer service where for a misconduct or a performance issue where you'd be required to go through the full range of a formal warning, final written warning before you can get to dismissal. So that bit likely to be cut out through this modified process, but some shortened process, simplified process for people in their probationary period. So that's going to be the case. However, the probationary rules, the initial period rules, will apply to dismissals for conduct, performance, breach of a statutory restriction. So in other words, it's illegal to employ the individual, and some other substantial reason dismissals. So the key one that's missing from that list is redundancy. So there is going to be no concept of a probationary initial period process for redundancy. So in the case of redundancy, every employee from day one will have the right to claim unfair dismissal and be treated the same way as everyone else. So that's probably going to be the most significant to start off with. So just moving on to the next slide, there are a few things that are subject to ongoing consultation, so we're waiting to hear the detail of those. The first one is going to be this probationary period, the initial period, how long that's going to be. What we have been told for certain that it will be somewhere between 3 and 9 months. Government's initial proposal was 9 months. Trade unions have been pushing for a shorter period, likely to be 3. So that's subject to consultation, and it will end up somewhere in that range and that's what we're looking at for this initial period of employment, the probationary one. Second thing is, as I mentioned before, steps for this modified procedure. Obviously, there'll be consultation about exactly what that should look like. And then the third one, which is quite interesting, is there's consultation as well about whether compensation for dismissals in that initial probationary period should be exactly the same. So at the moment, so by and large, unfair dismissal claims can, a successful claimant can claim up to a year's pay, subject to an upper cap. The thought is whether there should be some recognition that if someone is dismissed during their probationary period and it's on a procedural failing only, whether there should be a percentage reduction, and it shouldn't be quite as much. So, watch this space on that one. We'll see how that pans out. So just to give you a couple of scenarios, just to illustrate the differences that the new laws might bring or likely to bring. So first one, we've got Amy. She's worked for your company for 2 months. Her performance when she starts has been lower than expected. Her manager feels that she's just not picking things up quickly enough, not really showing the right signs of development. So she's invited to a meeting. Concerns are discussed, and she's given her notice. So under the new laws, when they come in, Amy will be within her initial probationary period, and therefore, as long as the company follows the modified, shortened process, and let's assume for these purposes that involves having a meeting, her right to respond, then in that case, that can still be a fair dismissal, even though she hasn't had the warnings and all the rest, because she's in her initial period. Whereas in contrast, in a separate part of the business, cost savings are needed, and a team of 5 is going to be reduced to 4. 4 of the 5 employees have been there for more than 2 years. However, George only joined 6 months ago, so he's picked for redundancy on the basis of his short service. Now, under current law, that would carry very little risk because George has not got 2 years service, and in a lot of redundancy cases, that's exactly what employers look to do first, is look at people with less than 2 years service. They carry less risk, apart from anything else. However, under the new law, that won't work because there's no initial period, there's no probationary period for redundancy purposes for George. So George must be included in the selection pool and normal selection criteria used. It might be that George is picked after that, of course, and that would be a fair dismissal. But in terms of the process, he has to be treated the same. If he's not, if he's just automatically picked without process, based purely on his length of service, then that will be an unfair dismissal. So the next thing, just following on from something that Greg picked up in terms of changes that have came in last year, there's going to be a further development in terms of flexible working. So Greg has already mentioned sort of the more recent change is it became a day one right to request flexible working. And going forward, the reasons for refusal are going to be exactly the same as we've got at the moment. So there are 8 listed reasons that an employer can give for rejecting a request. That stays untouched. But the changes that are going to be brought in is that the refusal of a request has to be reasonable. That's not written into the legislation at the moment. I mean, I'd like to think that most of you dealing with a flexible working request would be entirely reasonable about the rejection. And of course, we always have to be mindful of potential discrimination claims in the background, another reason to be reasonable anyway. But this will be expressly set out in the flexible working regime going forward. And essentially, if an employer refuses a request, what the legislation says is that they must first of all have to give the reasons and grounds for the refusal, but also explain why they think it's reasonable. So that's that last bit is an extra thing that we're going to have to do, is actually sort of spell out why it is that we're being reasonable in rejecting a flexible working request. And then again, another one that Greg mentioned in terms of prevention of sexual harassment, that's going to stay the same, but Labour have gone a few steps further. So at the moment, what we have as of October last year, as employers, we're under a duty to take reasonable steps to prevent sexual harassment of our employees. That the word all is now being included there. So now employers must take all reasonable steps to avoid harassment. So it just raises the bar that much higher going forward. In terms of what reasonable steps are likely to be. Greg's already given you some examples about what we think is likely to comply at the moment, but there is scope for regulations to be published as well that will specify what would classify or be classed as reasonable steps. So that will be a sort of a helpful tool going forward to make sure that, to double check that we're being fully compliant. So we've got a sort of helping hand there. And then the third thing, which is an important shift, is that employers will also be liable for acts of third parties. So at the moment, again, there are some exceptions or potential loopholes that exist at the moment, but it's not expressly included with the in terms of preventing sexual harassment. We're talking about preventing harassment of your employees by your other employees. But going forward, you are going to be under an express legal obligation to prevent harassment of your staff by external third parties as well, if that conduct is being carried out or in the course of employment. So if there's a connection between the third party and your employee and the harassment, then you can be liable for that going forward. And you need to take reasonable steps, or rather all reasonable steps that you can to prevent that from happening. So just to give an example, a female employee complains to a manager that a customer has been making unwanted sexually suggestive comments towards her. The manager does nothing, finds it too embarrassing, too awkward, doesn't want to upset the customer, so doesn't address it. The behaviour continues. Under current law, arguably the female might still be able to bring a claim, but might purely on the basis of perhaps an indirect sex discrimination angle, saying, as a female employee, I'm more likely to be harassed by customers than a male counterpart might be, and therefore by not protecting me and not taking action, I'm being discriminated against indirectly on grounds of my gender. But it's not the most straightforward claim to bring. Under the new law, it will be black and white. An employee is under a duty to take all reasonable steps in this scenario. The manager's been told about it. So even putting aside any steps they might have taken to preempt it and avoid it happening in the first place, the manager has been put on notice and does nothing. There will be liability and an uplift in compensation of up to 25% as well. Just very briefly on trade unions, so I won't go into the fine details. A lot of the detail is still to be published in regulations anyway, but just a few highlights to draw to your attention. First one, fairly straightforward, is that there will be a change so that you will have a requirement to tell employees that they have a right to join a trade union in their employment contract, in their Section 1 statement. So that's their employment contract. So that's one thing. And then the other pieces are essentially around simplification. The rules at the moment around a trade union either trying to ballot for recognition or for recognised unions for a formal industrial action are all quite convoluted and complicated in terms of numbers of employees within bargaining units, number of employees who are members of the union, who can vote, who can't, percentage thresholds, and all the rest. And essentially what the changes will be, again, likely to be towards the back end of 2026 when these come in. It's going to be all of those rules will be simplified so that it will just be a simple majority of the voters who actually vote can pass these things through. There'll be also be sort of a shortening of timetables and those sorts of things as well. So basically, there'll be a raft of new regulations and laws around trade unions just to simplify the processes. Yes, it will make recognition a little bit easier, but it'll also make it less confusing going forward. And then fire and rehire. Again, I think it's probably another really big headline one when this raft of legislation was announced. As a reminder, what we mean by fire and rehire, it's the process that an employer might go through to try to force through employment contract changes. In other words, you might have spoken to your staff, consulted with them about proposed changes, and you just hit a stalemate. The changes are important for the business. So what you then do is you say to employees who haven't agreed to the contract changes that what we're going to do is we're going to give you notice to terminate your current contract. We're going to offer you new employment going forward, so you're not being fired outright. We are offering to rehire you on our proposed new terms and present the employees with that choice of either you sign the new terms, in which case you've agreed, you've been rehired, continuous service still preserved and all the rest, or you fail to sign the new contract, you don't agree to it, in which case your notice runs out and you leave the business. So that's what we've got at the moment in terms of what we call that sort of fire and rehire. What the new laws will be is that starting point is that any fire and rehire process will be automatically unfair. So it will be an automatic unfair dismissal if an employee is dismissed for refusing to change terms, or you go through that fire rehire process, they choose not to sign new contracts, they leave, it's an automatic unfair dismissal, unless there's only one exception really. And that will be that the employer has to be able to show and prove evidence of financial difficulties affecting the viability of the business. So effectively, that will be the threshold to say that our financial viability is affected. We have to make these changes because of that particular reason. Also have to show that the changes proposed will actually eliminate or significantly reduce that particular risk, and that the need changes wasn't reasonably avoidable. In other words, it's a matter of last resort affecting the financial viability of the business. So if you can show those things, you can still do it. In all other circumstances, changing employment contract terms through that method will risk claims of automatic unfair dismissal. Other things as well connected with that is that, even if you've got that potentially fair reason slash the carve out in terms of the financial viability, it's not automatic there will be a fair dismissal. You still need to have consultation with trade unions or employee reps, depending on employee numbers, if there's 20 plus, and in all cases, consultation and normal process with employees as well. So you still need to tick all the right boxes for a fair dismissal. The other thing that's really important that sort of ties all this together is that sometimes it can be something of a toothless threat, the whole regime, because yes, an employee might have an automatically unfair dismissal claim, but that still involves them bringing a claim under current tribunal workloads and backlogs and all the rest. It could easily be 12 to 18 months before an employee gets in front of a tribunal, and of course that in itself puts people off. So if you're faced with the choice of saying, well, it's an automatic unfair dismissal if I don't accept this contract change, or but that involves a lengthy waiting litigation, or I can just accept the change. Yes, it's the original process was unlawful, but I want to keep my job, I want to keep my salary, so that I have no choice. So that's the dilemma that employees are put in. So what the government are consulting about is putting in what we call interim relief for employees in this situation. And what interim relief means is it's a very quick process, so there's no lengthy wait for the employee. And what the tribunal would grant is say to the employer that while a claim is pending, you must re-employ the individual. And in the meantime, or if you can't or don't, you have to pay their salary in the meantime. So that is, I think, to make the whole thing work, it kind of has to have that bit, because otherwise, as I say, for practical reasons, the law's there, but we're fairly toothless. So I think it's likely that this will come in, because otherwise, without that tool, it doesn't really work. So again, that would be certainly one to watch in terms of how that one develops. So again, just to highlight with a couple of scenarios. First one, again, reasonably common in our experience that this sort of thing could crop up. So a business has gone through a number of restructures over the years, acquiring other businesses, moving employees from one group company to another. And because the employees, you've then got sort of a mishmash of employees from all sorts of different backgrounds. They're on all sorts of different pay, benefit, bonus, hour, holiday structures and all the rest. And it's all a bit messy. And because the employees now work all together in one company, they sit alongside each other. Some people have got some things that other employees don't have and all the rest, and it's causing disgruntlement. So what the business wants to do is it wants to go through an exercise to harmonise all terms, just going forward, put everyone on the same pay and benefits packages. The contracts will be beneficial in some areas, but reductions in others. So every employee will get pros and cons going forward. So that's kind of a classic example that we have now in terms of why you might want to go through this hire and refire process. I mean, hopefully you would sort it out through initial consultation, but if you didn't, then you have got that to fall back on. You've got a proper business reason as to why it's important. But under the new law, it's nothing to do with financial viability. It's just about, you know, the practicalities and disharmony and those sorts of things, which isn't covered as the exception. So if you followed a fire and rehire process in this particular scenario, when this new law comes in, it would become an automatically unfair dismissal for anyone who didn't decide to, who wasn't happy with the contract changes. And then, yeah, contrast that with scenario B. So you've got a very generous salary and contractual bonus structure in place, which you had to have to entice new recruits when the market was at its absolute peak. But you're now facing much tougher times. You're making a loss. And the position is, if you don't make the changes to the overall pay packages, you'll need to find savings by cutting jobs, redundancies, and suffering, and the company suffering financial loss. So in that particular scenario, it may still be possible. Yeah, there are still the thresholds to meet in terms of be able to establish that it affects the viability of the business and that there wasn't any alternative that could have avoided this. But that's the type of scenario where we might still be able to use this process, and it's the only one in which we could use it. So just a few other fairly quick things on the Employment Rights Bill. First one is in terms of bereavement leave. So at the moment, we've got parental bereavement leave for parents who lose a child, but beyond that, there's no legal statutory right to bereavement leave beyond that. So if you lose a different family member, spouse, anything like that, there's no legal right. An employer might grant it, but there's no statutory right to bereavement leave. So the idea is that that would be brought in, and it will be brought in as a day one right. But basically, it will be unpaid. So parental bereavement leave for loss of a child will still be paid as normal, but this extended right to bereavement leave will be you'll be entitled to a week of leave, but it will be unpaid leave. So that will be coming in due course. Then some quick change on parental leave and paternity leave. It's going to become a day one right. So at the moment, there's a qualifying period of service for someone who wants to take that type of leave. So that's going to disappear. And then secondly, sort of a slightly more technical one is that employees going forward will be able to take those types of leaves after the end of any shared parental leave and pay. So for technical reasons at the moment, you can't do that. You have to, if you take your shared parental leave, then you can't take paternity leave afterwards, but that will shift going forward. So you've got more flexibility as an employee to take the different types of leave at different times. This is potentially quite a significant one, and I say potentially only because this particular one is in the bracket of everything that I've mentioned up till now is all legislation that will be coming in. So most likely towards the second half of 2026. This one is in the bracket of it allows regulations to be put in force in the future. So it's not guaranteed that it will come in, but the legislation has set the groundwork for bringing it in the future. And this really follows on from the point that Greg mentioned earlier on one of his cases about pregnancy and people returning from maternity. So as Greg mentioned, we've currently now got the extended protection for people on that goes beyond just people on maternity leave. So they are protected from the point they inform their employer that they're pregnant, and it carries on from 18 months after the expected date of childbirth. So basically, if someone takes a year of maternity leave after the child's born, they are still protected for 6 months afterwards. And as Greg mentioned, what we've got under current law is this Regulation 10 right that gives those people preference over suitable alternative roles. But that's as far as it goes. What the potential proposed change is that this will cover all dismissals. So effectively, apart from very specific circumstances. So it's probably likely to be, gross misconduct and closure of the actual workplace, so the business completely shutting down. In all other circumstances, potentially any dismissal of anyone in that protected period will be unlawful. So that's quite a significant change. But as I say, that's one that's it's there. It sets the groundwork to allow it to be brought in the future, but we haven't got any particular timetable. It's not guaranteed that it will come in either. So other final bits on the Employment Rights Bill itself is, first one quite simple: statutory sick pay. At the moment, the first 3 days of sick leave under the statutory regime are unpaid. It's only from some day absences of 4 days or more that get paid statutory sick pay. That will disappear, just become a lot simpler. So the statutory sick pay gets paid for any sickness absence right from day one. And then separate to sick pay, another one that's potentially significant overall is that at the moment, for the vast majority of employment tribunal claims, there's a 3-month time limit. So the employee has to bring the claim within 3 months of the act they're complaining of, and that is likely to be extended to 6 months. So it's already a bit of a pain in terms of that waiting time where you have dismissed an employee and often you don't hear about it for quite some time. So if an employee, we've certainly known cases where a good 5 or 6 months have passed, you think you're in the clear, and then all of a sudden a tribunal claim pops up, and effectively what's happened is the employee has got in touch with ACAS within their original 3-month time limit. It's gone nowhere with ACAS, so you're not even contacted by ACAS. It goes through that process. The employee's then got another month to bring their claim. They do that. The tribunal then takes a month or so to process it, and then all of a sudden, we're 6 months down the line, and it's the first we hear about it. And you've got that period of uncertainty after someone's been dismissed to work out if there's a problem or not. So the fact that that will be extended for 6 months. Again, it remains to be seen whether that will result in an increased volume of claims. Potentially it might, if employees are waiting to see if they can find a new job quickly. And if they do, they don't worry about bringing a claim, but with a bit more time to think about it. And if they haven't got a new job, possibly will increase volume of claims. But again, I think more significantly is that extended waiting time. The fact that you've got potential witnesses to the event, even more time has passed before we get to tribunal, all of those things. So again, key thing will be keeping evidence fresh at the time, keeping records at the time, so that memories don't fade over this extended period. So that's it on the Employment Rights Bill. The final thing to mention, which actually is kind of slipped under the radar quite a lot for a lot of people, but got announced in regulations that have been laid before Parliament last week. And this is a new right that is due to come in on the 5th of April this year. So it's all coming in fairly soon. And what this is the right for employees to take what we call neonatal care leave. So the regulations themselves, as with all legal regulations, fairly complicated trying to get your head round when reading through them, but I've tried to distill the key concepts here. So first of all, in terms of when the right arises, well, it's going to be an entitlement for parents of a child or those with caring responsibilities for the child, and it happens where the child in question receives neonatal care, and that basically means it's hospital treatment or ongoing medical care or palliative end-of-life care. So they might have left hospital but still under the care of a medical professional, and that has to start within 28 days of them being born, and the care needs to last for at least 7 days. So if the child meets those criteria, then the parent or the care of the child qualifies to take neonatal care leave. It's a day one right, so to take the time off, employees don't need qualifying service. It's any employee can take it, and but for pay it's slightly different. There is the requirement for qualifying service, which basically is the employee must have 26 weeks of service by the 14th week before the baby's due date or the match for adoption. So exactly the same kind of timescales as for maternity pay. So it's always quite confusing when it's set out that way of 26 weeks before the 14th week or for the EWC, but it's exactly the same wording as for the right to the statutory maternity pay. So employees get paid leave need that. In terms of the amount of leave, well, that will vary depending on how long the child is receiving neonatal care. So if the child receives neonatal care for 8 weeks, then the employee is entitled to 8 weeks of leave. So that's basically how it works. There's a direct correlation between the two, up to a maximum of 12 weeks of leave in total. In terms of other restrictions, it can't be taken in the first 7 days after the child's born, but it then can be taken any time after that. So it doesn't have to be taken at the same time that the child is actually receiving the care. The time the child is receiving care is simply dictates how much leave the employee becomes entitled to in due course. However, the rules are slightly different depending on whether you take the leave during the care period or afterwards, just in terms of the type of leave that's requested. And basically what I mean by that is if you take the time off at the same time that the child is receiving the care itself, it needs to be booked off in blocks of full weeks, but they don't have to be consecutive. So you could have 2 weeks of leave, come back to work for a couple of weeks, have another 2 weeks off, for example. Whereas if you take the leave after the end of the child's actual care period, it has to be taken as a continuous period. You can't take weeks here and there. It would have to be 4 weeks in a row, for example, and that would be it. That would be the end of the entitlement. And then the final limitation is that any leave has to be taken within 68 weeks of the child's birth. So again, as with any type of new law and leaves, I think shared parental leave was the one that was an absolute headache to get your head round. There are some potentially confusing concepts in there, but hopefully that's kind of sets out the key principles in reasonably simple form. And as I say, that will be coming into force on 5th of April this year, which basically means it will apply to employees whose children receive neonatal care from the 5th of April onwards. So if a child started receiving neonatal care in March this year, the employee doesn't get the right to start taking leave in April onwards. It has to be where the actual care itself, all of these bits and pieces have to be in place after 5th of April this year. So that is everything I was going to cover, which leaves us, does anyone have any final questions?
Okay, thanks, Will. So there's 3 questions in the Q&A. If you want to add any questions, please do so. Let me take questions from Lisa and Catherine, Will, while you read the question from Robin. So question from Lisa. Hi, Lisa. If as a company we don't recognise a trade union, will we still have to give the option in their T's and C's? So just to be clear, the obligation in the contractual obligation in relation to trade union membership under Section 1 of the Employment Rights Act 1996 is to confirm whether there's any collective agreements in force in relation to those staff. And if there is, you will state that, and if there isn't, you say there are no collective agreements in place. So the union recognition as such doesn't have to be stated as an option in the contract. What you need to do is just to be clear in the contract whether there's any collective agreements in place. Nothing changes in relation to that. And then Catherine, you asked a question about sexual harassment training. Should this be presented in a certain way? Is it good enough just to ask them to read it? Well, there's all sort of different ways of delivering training. A lot of businesses are doing e-learning for sexual harassment training, but equally there's some businesses who are getting trainers in, and certainly Will and myself and others in the team have been into clients and delivered training on sexual harassment. If you give them some e-learning, then that is okay. Obviously, the more you do, the better, and the more frequently you offer training, and the more broadly within the business you offer training, the better. As a minimum, managers, people who are managing staff should have training, but some businesses have been offering it to all staff, just to sort of make them aware of the issues around discrimination, around protected characteristics, and so on and so forth. If you just gave them a manual or gave them a policy and said to your staff, read it and then tick a box to say you've read it, well, that's probably the least attractive option in terms of meeting your obligation. It may be of minimal assistance if you went to a tribunal and were defending a sexual harassment claim. But obviously, the more you can do, the better. The more engaging and broad it is, the better. So yeah, most employers are certainly as a minimum doing e-learning, and many more are doing in-person, face-to-face sort of training. And that's something which, if you wanted us to help you with, then we'd be delighted to do so. Will.
Yep. So the question from Robin was, are there any new considerations for employers with regards to health capability dismissals under the proposed changes to unfair dismissal rights? I mean, on that one, the short answer is that there's nothing in the new proposed legislation that changes anything or makes a special exception for health dismissals. So if you were going through a health capability dismissal, the same concept would apply in terms of the initial probationary period. So you would need to follow the modified process to avoid automatic, to avoid an unfair dismissal for those types of claims. So those would be exactly the same. But that said, with any type of health capability dismissal, possibly lurking in the background is disability discrimination, depending on the particular health issue. So even under current law, because discrimination rights apply from day one of employment, you always have to be a bit careful when going through that type of process, rather than, sorry, you're on your probationary period or in your first 2 years of employment, and simply dismiss the employee. If there's a disability angle, that's something you would want to explore already, and that will be exactly the same going forward. So bottom line is, chance that we'd be following very similar processes to those we do already. But if there was no disability angle, then a health dismissal in that initial period will be subject to the modified process. After they've got through the initial period of employment, then they would have full unfair dismissal rights. So full process exactly the same as you would follow at the moment for someone with 2 years plus of service.
Good. Thanks, Will. And thanks for your questions. I can't see any more questions that dropped into the Q&A. So on that basis, I think we are done for this session. Thank you for joining us. As a team, we are just building our program for 2025. We had a good session as a team yesterday in terms of what topics we're going to be covering in our podcasts and webinar and other content during the course of this year. If you have things which you think will be of interest to your business, then always get in touch with your DMH contact. But for now, we will draw it to a close there. Thank you for joining us, and we look forward to seeing you again at one of our later sessions in 2025. Thanks, and have a good day.